Corporation and others.
The judgment will be delivered by Lord Mance.
The appellant VTB Capital plc, which I shall call VTB, is an English subsidiary of a Russian bank, VTB Moscow. VTB made a loan to a Russian company, RAP, to enable it to buy some Russian dairy companies. The seller was a British Virgin Islands company, Nutritek International Corporation, which is alleged to belong to a Russian businessman, Mr. Malafeev. VTB says it was induced to make the loan by two representations. First, as to the buyer, RAP's independence of the seller, Nutritek, and secondly, as to the value of the Russian dairy companies, as stated in an accountant's report. It says that Mr. Malafeev in reality controlled both Nutritek and RAP, and that the report grossly overvalued the dairy companies, and that the loan has as a result proved largely irrecoverable, so that VTB has suffered loss approaching $200 million. VTB obtained permission to serve and has served English proceedings out of the jurisdiction on Mr. Malafeev, Nutritek, and another British Virgin Islands company alleged to belong to Mr. Malafeev. The claim is that these defendants, by deceit or wrongful conspiracy, induced VTB in England into making the loan. At the same time, VTB obtained a worldwide freezing injunction against the defendants' assets. After service, the defendants applied to set aside the service out on the ground that England had not been shown to be clearly the appropriate jurisdiction to resolve the claim. They also applied to set aside the freezing order on the same ground and as having been obtained by non-disclosure. In response, VTB applied to amend to rely on a further head of claim, namely that the alleged deceit and or conspiracy entitled them to look through RAP's corporate veil and to treat the defendants as party to the loan contract, thereby entitling VTB to invoke English jurisdiction under express provision in the loan facility entitling VTB to sue the borrower in England. Both Mr. Justice Arnold and the Court of Appeal, for somewhat differing reasons, acceded to the defendant's application, refused VTB permission to amend, and held that the freezing order should be discharged, but suspended the discharge pending any appeal. The Supreme Court, by a majority of 3-2, dismisses VTB's appeal on the issues of jurisdiction and amendment and removes the stay on the discharge of the freezing order. On the question whether England has been shown to be clearly the appropriate forum, the Court holds that the alleged tort of deceit and proceeds on the basis that the alleged conspiracy were committed in England and are subject to English law. But it concludes that although the place of commission of a tort is a useful starting point, and not infrequently a finishing point when deciding where a tort claim should appropriately be litigated, it is no more than that. And applying the House of Lords guidance in the Spiliada, the ultimate test in a case of service out is which court is, in the light of all the circumstances, the appropriate one to determine the issues in the case, the burden here being on VTB to show that England was clearly the appropriate jurisdiction. Here, the majority concludes that there was no basis for interfering with Mr. Justice Arnold's judgment that England had not been shown to be the appropriate forum, a judgment which he reached on the basis that the representations originated in Russia and their subject matter and correctness, as well as the likely witnesses, were all in or much more closely connected with Russia than England. The fact that the loan allegedly induced by the torts was subject to English law is a relevant but not decisive factor when deciding which is the most appropriate forum. I'm sorry, that should read the fact that the loan allegedly induced by the torts was committed in England is a relevant but not decisive factor when deciding which is the most appropriate forum. Although Mr. Justice Arnold was wrong to hold that Russian law governed the alleged torts, he had also made clear that an opposite conclusion would not have affected his ultimate judgment on the inappropriateness of an English forum in any event. More generally, the majority draws attention to A, the need to ensure that evidence and argument on issues of foreign convenience should be kept within proportionate bounds, and B, the inappropriateness of appeals brought in the hope of persuading a higher court to interfere with an exercise of judgment reached below in a field where differing conclusions can be reached by different tribunals without either being susceptible to legal challenge. It also addresses the consequences where a defendant seeking to set aside an order for service out chooses merely to rest on a denial of liability without disclosing any positive case as to his or its defence. As to the application to amend to look through VTB's corporate veil, the Court leaves undecided the question whether any doctrine of lifting the corporate veil exists, apart from circumstances where the language of a statute expressly or impliedly requires or permits it. Assuming it can, the Court concludes unanimously that this is not a case in which the doctrine can possibly enable VTB to hold Mr. Malafif, Nutritek, or any other of his alleged companies liable on a loan contract which VTB asserts that these defendants deceived it into entering into. Permission to amend was accordingly rightly refused below. Finally, the Court, in discharging the freezing order, regrets the situation which has arisen whereby a freezing order which Mr. Justice Arnold held should be discharged 14 months ago, even if service out was not set aside, has continued to date without it ever being determined whether it was right to discharge it on that basis at an appellate level.